Hello, I'm sbagne, and this post is going to talk about the definition of parcel. Before undertaking an appraisal to determine just compensation, it's necessary to identify the appraisal problem. The appraisal problem includes evaluating what property needs to be included in that appraisal report. The Uniform Condemnation Procedures Act contains a definition of parcel, which I'll read to you. A parcel is an identifiable unit of land, whether physically contiguous or not, having substantially common beneficial ownership, all or part of which is being acquired and treated as separate for valuation purposes. This definition has two important elements to it. First, the property does not necessarily need to be physically contiguous. Second, the property does not need to have precisely the same ownership. For example, if there are two limited liability companies that own contiguous parcels of property with common membership, that would count as being part of the same parcel. The area between the ballpark and Woodward Avenue is filled with parking lots. Most of these parking lots are owned by the Stadium Authority, but one parking lot survived and remains in private ownership. Why? Because of the definition of parcel. This parking lot is owned by the Central United Methodist Church. If the Stadium Authority had tried to acquire this parking lot, they would have needed to pay the diminution in value to that church. It would have been quite costly, so the Stadium Authority left them alone, and the church was able to keep its parking lot. Unlike the example that we just saw, agencies often fail to identify the larger parcel when evaluating just compensation. It's important to explain how your property is used and how it's intended to be used in the future to an experienced eminent domain attorney to help identify what the appraisal problem should be and whether the definition of parcel comes into play.